I'm here with Mark Joseph from the Democracy Fund, who's been kind enough to share a few moments with us and share his insights into what he's observed so far in the trial of Chris Barber and Tamara Lich.
The two are being charged with a series of crimes related to their organizational roles over the freedom convoy that took place in the nation's capital in 2022. Now, this was easily the largest peaceful demonstration in Canadian history, and the two are being charged specifically with mischief, intimidation, obstructing police, and counseling others to mischief and obstructing police. We got the chance to sit down with Mark A. Joseph, who's the senior litigation counsel at the Democracy Fund. And the Democracy Fund itself is a Canadian charity that describes itself as being dedicated to constitutional rights, advancing education, and relieving poverty. Now, Mark was in the courtroom the entire week, and we wanted to ask him what he thought the major takeaways were, what his insights were, and here's our interview now.
So, Mark, you've been in the trial for this week. And let's talk a bit about what we were discussing earlier in terms of this timeline dispute. So there's a little exchange at the end of the day today in which the defense, the prosecution had this back and forth regarding expected timeline for witnesses that the prosecution seeks to enter into evidence. Maybe you can share with our audience a bit about what you observed about that and how that impacts potential issues going down the line.
Sure. So correct me if I'm wrong, but I think we are on day 8.
Yes.
And there was 10 days allocated for the Crown to present its case. And I think the Crown maintained that they had 22 witnesses that they were going to call. And we've gotten through, I think, 2. Lucas, I believe, the first day. Right. And then there was Cyr, but she has to be recalled. And then Sergeant Pilote, I believe, just finished today. So that's 2.5 witnesses out of 22. And we're on day 8 of 10. And then there's some discussion that perhaps Justice Perkins LeVay would be able to carve out another 2 weeks sometime later, maybe in November, for additional court time to be allocated. But let me tell you why that's a problem. Because there's a rule, we call the Jordan Rule. It's from a case, Supreme Court of Canada case called R.V. Jordan, which says that for in provincial court, at least, the Crown must complete its case within 18 months. So between the time the information was laid to the time the trial finishes, it has to be 18 months. If it's longer than that, there might be a charter breach. So the defense might be able to argue that the rights of the defendants were breached because the trial wasn't completed in a timely manner. And so it seems like we're pushing those 18 months. We might be if we can't get this trial completed within 18 months. So I don't know if that's going to be an issue, but I just know that the courts are very busy and that might become a problem.
I mean, basically, if the past is prologue and it took 8 days to get through 2.5 witnesses, as you put it, it's just not going to be able to get completed in time, especially given the defense having their allocation for their witnesses, their challenges. So we actually spoke with Lawrence Greenspan at the end of the day very briefly, and he sort of said this would be addressed on Monday. We'll get to see some of that. And another thing I wanted to ask you about was the presentation by the defense of this video in which Brian Pickford, who is important to us as Canadians, given his role as a composer, one of the drafters of the Canadian Charter of Rights and Freedoms, was giving this speech over at Wellington, right in front of Parliament Hill, regarding how rights were being violated in the context of what I call the COVID-19 enterprise.
Don't be fooled by those who try to tell you that somehow you can skirt around the Charter of Rights and Freedoms. I was there, I helped write the damn thing, and they're wrong, and we're right.
And you and I were discussing how that relates to what you said was color versus play-by-play. And I wanted you to just share those remarks because they were so great with our audience, how you assess that, how you assess the strategy of that, the airing of that video.
Sure. Well, first, let me say I'm not privy to the defense strategy.
Gotcha.
And this isn't legal advice. This is just my understanding and my opinions. But people are storytellers and story listeners. So there's different ways to analyze the presentation of the defense and the Crown. And one way to do that is just to look at the evidence and ask, is it strictly relevant to the charges? Because remember, the Crown has the onus to prove its case beyond a reasonable doubt, and the evidence must correspond to each element in a charge. And so they should stick to that. They should do the play-by-play, strictly speaking. But of course, there's, like I said, people are storytellers, story listeners, so they might want to talk a little about color, the things that aren't strictly legally relevant. The defense also might want to do this sometimes if that's part of their legal strategy. And so that's how you might want to analyze this type of evidence with respect to Brian Pickford. Brian Pickford, of course, is was one of the drafters of the original Charter of Rights and Freedoms. And so his speech that you saw in the video today in court wasn't strictly legally relevant to the charges or a defense, perhaps. Nonetheless, he's a compelling speaker, and he lent his voice to the protesters in the Freedom Convoy. And I think that is color commentary that goes to show that this wasn't necessarily a violent protest, perhaps. But people can draw their own conclusions. But that's maybe one way to look at this type of evidence that is not strictly relevant, but also might be useful.
I'll add a little bit of color to that color commentary in terms of what I observed. So I was in the same courtroom. I saw that. I had the same assessment that you just shared, in which it didn't seem legally relevant to me. It didn't seem like this story or this video of Brian Pickford was undermining or somehow challenging the specific charges. However, it added color and flavor. It was a story. And I'll share my observations of what the judge did in terms of her reactions. She sort of picked her ears up a bit when she saw Brian Pickford. She actually wanted a replay of part of the video because it was quite fuzzy. I've never seen her do that in the previous 8 days. So she wanted to ensure that it indeed was the Brian Pickford that she knows. And then there was a point in time when one of the prosecutors, Tim Radcliffe, said that he was unfamiliar with Brian Pickford, had not seen him before. The judge seemed surprised by that. She sort of did a little self-deprecatory joke where she's aging herself. But the fact that that really captured her attention in a way that I'd not seen in the earlier 8 days spoke to perhaps the efficacy, the success of this strategy, assuming this was part of the intention of the defense and the airing of that video. So yeah, to your point, I love that human beings are storytellers and story listeners. We're not just robots. We don't get persuaded just by play-by-play.
Right.
We want flavor, not just roasted chicken. We want some seasoning on there, right?
Right. So, I mean, I don't know if you noticed, you probably did, but at the end of Mr. Granger's cross-examination of Sergeant Pillow, Mr. Granger, of course, being one of the co-counsel for Tamara Lich, it was the cross-examination where the video of, I guess, 2 MPs were speaking on camera, and they were mentioning that people should come to Ottawa, I believe, my memory serves, and that people should remain peaceful.
Yep.
And there's bouncy castles here, et cetera, and that was put to Sergeant Pillow. I don't know if she remembered. She said she remembered reviewing that. Nonetheless, the video was not challenged as being inauthentic. So the last question Mr. Granger asked was, were either of these MPs charged with anything relating to the Freedom Convoy, of course. Now, that's not strictly relevant, whether or not they were charged, whether or not someone else was charged for similar offenses. Nonetheless, MPs aren't being, they're saying, it seems like they were saying, come to Ottawa. That seems like it's an encouragement to, come to Ottawa during the protests. And they didn't get any trouble. And people, like I said, people have a belief in fairness. And that seems like, okay, what's going on? Is there a double standard play? I'm not suggesting there is, but that question was put to Sergeant Pillow, and I believe she said she didn't know. Again, not strictly relevant, but the color aspect is there, as you can see.
If you value and appreciate our on-the-ground, in-the-field reporting, please understand we can't do this for free. We need your support. Please go to tamaratrial.com and chip in what you can so we can keep the news coming to you.